In the early 1900s, Northeast Oklahoma was a hotbed of legalized theft of Native American land, oil and mineral rights, and even lives. Local government, state government, legal professionals, business owners, all in on it. And as the pages of some historical records indicate, people would even pit family members against each other to advance their own greedy ambitions. This corrupt probate system operated through Native Americans being determined incompetent and thus unable to handle their own financial and business affairs. They were then assigned a guardian to handle their affairs for them, supposedly in their best interest. This was normally a white person, but not always, as was the case of Sally Morrison. Sally and her husband Henry were approved for citizenship in Mvskoke Creek Nation in 1899, along with their two children, Jerry and Duffy. Jerry was 10 and Duffy was 5. It is worth noting that Duffy was also later cited as an imbecile and had been since infancy. When their citizenship certificate was issued in 1902, all were marked down as half Creek by blood. But as the records in 1904 show, when Sally tried to get her son John on the Dawes rolls after he had died, she needed to speak through an interpreter, Mr. Alex Posey, meaning she did not speak English, only Creek. Fast forward 6 years after Sally needed an interpreter to file documents with the Department of the Interior on behalf of her son John, something out of the norm was about to happen. In 1910, Sally had two attorneys, an H.B. Schaefer and another by the name of Kerrigan. Through a court order approved by Tulsa County Judge N.J. Gubser, Thomas Blair was discharged as incompetent Duffy's guardian, and Sally, his Mvskoke Creek mother, was appointed as his replacement. Sally started issuing oil leases beginning in 1911, then more in 1912. It was an estate that would soon skyrocket to millions of dollars in value. In 1914, Tulsa County Judge Con Lynn approved Sally's guardianship over her other son, Jerry, as he was also deemed incompetent. In July of 1918, Sally's son, Jerry, was drafted in the First World War. He died just 3 months later at Camp Dix in New Jersey and is referred to as a World War veteran in court records. By then, much of Duffy's millions were gone. In 1923, the Attorney General's office ordered an investigation be made into the probate matters impacting the Mvskoke Creek Nation, Cherokee Nation, Chickasaw Nation, Choctaw Nation, and Seminole Nation, known as the 5 civilized tribes. The investigation was conducted by Shade E. Wallen, superintendent of the 5 civilized tribes of Oklahoma. In Wallen's report, Duffy Morrison is referenced as about 30 years old and an incompetent, invalid, crippled, and helpless person that constantly requires an attendant. His legal guardian is still his mother. His case report showed more than $250,000 was received and spent from Duffy's accounts from 1910 to 1915. That's more than $7 million in today's money. The case also showed the court approved on multiple occasions for Sally Morrison to borrow from Duffy's estate, including thousands on unsecured personal notes, which was never repaid, and large investments of Duffy's money in loans on real estate securities, which were not repaid. Other expenses involved more than $21,000 owed to a chauffeur who apparently drove Sally around nearly every day from 1918 to 1923, but the rides weren't related to Duffy or Sally's guardian duties, and no information was made available as to destinations or purposes of any of the trips. In fact, no detailed statement of expenditures for the use and benefit of the ward Duffy were provided at all. In 1924, Sally resigned from being Duffy's guardian, citing old age. She passed away in 1931 after a series of illnesses. Duffy died 4 years later. While authorizing motions such as increases of Sally's compensation for taking care of Duffy, Tulsa County Judge Con Lynn was also close with Sally's nephew, Walter Anderson. So close, in fact, that when Walter Anderson died in 1927 at just 30 years old, he had 3 wills with 3 beneficiaries, and Sally and Lynn were 2 of them. 6 days after Anderson's death, Lynn filed a petition asking that the will in which he was named beneficiary be probated. Sally contested it, saying it was obtained by undue influence, suggestion, and persuasion on the part of Lynn because Lynn had been Anderson's attorney for a long time, and that Anderson was a drug addict and would do anything to obtain narcotics when the craving for such narcotic was upon him. The case went to the Oklahoma Supreme Court, where it was determined that Anderson did believe the county judge was his best friend, and the judgment in Lynn's favor was affirmed.